When you're a US citizen and you haven't spent enough time inside the United States, you won't be able to automatically transmit US citizenship to your children. This is something that's unexpected and really shocks a lot of people when they hear it, but it is the case that there's a requirement to pass citizenship that you spend enough time in the United States. It's a standard that says 5 years, two of which have to be over the age of 14. That has to be well documented to show the government to get either a CRB, a consular record of birth abroad, and a passport, and potentially a form N-600 certificate of citizenship for the child to really prove they're a U.S. citizen. But there are other options if a person is unable to get citizenship automatically to a child. One option of the two we're going to discuss today is that we're not going to discuss today is filing for a green card for the child, coming with them to live in the United States before they're 18. And upon being a green card holder residing with the U.S. citizen parent, they could become citizens as well. But that's a separate category right there, and they could file for passport and Form N-600 certificate of citizenship. Today, I want to talk about Form N-600k. It's a complicated one, not used on a lot, but we see a lot of clients asking for this in our clients, especially in the Middle East, if you will. That's a primary area where we're doing these because we have a lot of clients who come, their children got citizenship, and then years later, the embassy said, actually, we gave it incorrectly, take away their passports, and then they quickly act to see what to do. And in these cases, the parents, U.S. citizen, parent, at least one of them, does not want to move to the United States. They want to continue residing overseas in that home country, a foreign home country. And so then it's important what to do because they can't use that option I discussed of getting a green card for the child and moving to the United States to reside here with the child so they become citizens because they don't want to move to the United States. They have work and family and other issues and things they have to deal with in their foreign home country. So then what's the solution? Well, they created this form called N-600k and a statute based on it that allows you to get citizenship if you are going to maintain residence abroad. Now, for it, you need to have be able to transfer the number of the status from the parent. And so if you don't satisfy the years, that's a problem. But the extra exception they have for this is that you could use your grandparents' age. So most of these cases, if not almost all of them, we have a U.S. citizen grandparent who had a U.S. citizen child. The child didn't spend enough time in the United States, but the grandparent did. They have years and years of being in the United States. And based on that, they could transfer citizenship to that child by filling out Form I-600K, proving the relationship exists, the familiar relationship between those parties, the U.S. citizen parent and then the U.S. citizen grandparent of that parent, as well as documenting the physical presence of the grandparent in the United States. A lot of times this takes the form of school records from middle school, junior high, high school, college, and the like, work records, social security records, medical records. Many times parents or grandparents living here and going to hospital, doctors, ownership of property, ownership of other cars, homes, all the like, insurance. Anything we can get a hold of that shows they're physically here in the United States. Sometimes it's tax records and sometimes it's voting records. All these things to document 5 years worth of physical presence in the United States to be able to transfer that citizenship to the grandchild. So you get all these documents together, submit Form N-600K to the government, and eventually, if they accept the documents, the evidence of relationship and the grandparent's physical presence in the United States, and the child living with the U.S. citizen parent overseas, and the intent of that parent to remain living overseas. There's a lot of subcategories, sub requirements, and criteria that you have to satisfy. But if you get all this together, eventually they'll organize a time for the child to come to the United States. The child will need to have the ability to come to the United States. A lot of times they apply for a tourist visa. In some country, it takes a while to get those, so it's better to prep for that ahead of time. But when they get the tourist visa, they come to the United States for an interview. The interview usually is just a nominal thing for them to come. And once they do that, right now, hopefully it stays the same. They do the ceremony to get a citizenship pretty immediately, and the people could leave after that and apply for a passport in their home country. Preferably, you don't leave without a passport. They do it here, but sometimes time just doesn't allow it. The government says you're supposed to have a passport when you leave, but they've been pretty flexible about this historically. So you go to the U.S. Embassy and apply for there as well. But that's the situation with N-600K through grandparents. Again, we do it a lot. The key to this all is showing that the grandparent has a physical presence in the United States. Sometimes it's easier to get that, sometimes not. So we got to spend some time doing it. You might need to get an investigator if it just doesn't come easily. But these are the things to watch out for. It is possible to remain living overseas with your child, get them citizenship, get the passport without having to come and live here. And that's what the N-600K is about. I'll do a separate video later about the N-600 where you get a green card for the child and have it come to the United States to reside here. That becomes a problem too because if and it kind of goes to why we do the N-600K is we have families who get the green card for the child, come to the United States, and then as soon as they get here, they apply for a passport, get in and leave. They never actually reside here. And then 10, 15, 20, sometimes 30, 40 years down the line, they go to renew their passport, the child does, at the U.S. Embassy abroad, and the embassy says, when you got your green card, you came to the United States, live with your parents. Did you reside there? Show us evidence you actually stay in the U.S. And in fact, they only stayed here for a week or 2 or 3 to get their passport, and they left. They have no evidence. And at that time, 40 years after the fact, again, 40 years after, I have cases like this. They say, you know what? You're not a citizen. It was a mistake. We should take it away from you. So that becomes a disaster in those kind of cases. And if the parents were in such a rush to leave, potentially doing the N-600k would have been better if they have the physical presence requirement for the grandparent. But because they're not familiar with it, and this form is really complicated, understanding is just complicated the way it's designed, they just go for what everyone says online, N600, all that kind of stuff, and then they do that. So that's why I want to put these videos out there so you have some understanding of what options are available. There's other things that are possible. But if you want to schedule a private consultation about your case to plan out for your grandchildren and your child's future and ability to become a U.S. citizen and get a certificate of citizenship and all that kind of stuff and passport, please contact us. Go to our website, jqklaw.com/contact. Fill your name and contact information so we can reply to schedule a formal consultation and go into more detail, see what's going on so we can help you and your family. Thank you so much for listening, and I wish you the best.